Right, thank you, Martin. As we start, I would like to inform you again that this session is being recorded. And my name is Morgan Nico. I lead the human trafficking and migrant smuggling knowledge development and innovation team at UNODC. And I would like to warmly welcome all participants to the first UNODC Knowledge Week on human trafficking and migrant smuggling, and also to this very first event of the week. Today, and in the next days, we will be pushing the boundaries of what is known about human trafficking and migrant smuggling on matters such as genders, technology, criminal justice, and human rights. In our work, we pay special attention to how theory translates into practice, and we strive to inform policy development from an evidence-based perspective. We hope that this week will inspire you and raise questions that will stay with you, provoke you maybe, and more importantly, incite you to develop your understanding and knowledge in the human trafficking and migrant smuggling fields. Before we get to today's topic, I would like to give the floor to John Brandolino, the Director of the Division of Treaty Affairs of UNODC, who will welcome you through a recorded video.
Good morning. I'm John Brandolino, the Director for UNODC's Division for Treaty Affairs, and I would like to welcome you to our first ever Knowledge Week on human trafficking and migrant smuggling. Countries to develop and implement effective responses to these crimes that affect people. Through the services we provide, authorities are better equipped to prevent human trafficking and migrant smuggling, prosecute and convict the perpetrators, support victims of trafficking, and protect the rights of smuggled migrants. A key competence of our work is the development of publications and toolkits for training, research, and policy reform purposes that contribute to a greater understanding of human trafficking and migrant smuggling. We share knowledge globally to inspire, inform, and engage. Some of the tools we have published recently that are based on current evidence address the burning issues we are facing. These include the lack of justice for migrants who are abused in smuggling routes, and how victims of trafficking are being convicted for crimes they are forced to commit by the networks that are exploiting them. The unprecedented restrictions resulting from COVID-19 did not stop UNODC from continuing to expand this knowledge base on these crimes and connect with our global community of practice. We have stayed in touch to understand how you, our partners, have overcome these challenges. In July, we released a study on the devastating impact of COVID-19 on victims and survivors of human trafficking. It illustrated how traffickers take advantage of the global crisis by capitalizing on people's loss of income and the increased amount of time that both adults and children are spending online, while frontline responders, we found, have showed very much resilience and strength. Over the coming 5 days, you can take part in a range of thematic discussions that are based on findings and recommendations of our recent publications. You'll hear from criminal justice officials who will make use of the guidance provided by our studies and reports, and from representatives of international and non-governmental organizations, as well as members of civil society who support and value our work. Practice at the national level can be challenging. To combat these crimes, we need to be one step ahead of the perpetrators and fully utilize all possible tools available. So we often hear that knowledge is power, so let's use that vast wealth of knowledge provided by UNODC to work together to successfully counter these crimes. Thank you for listening, and good luck.
All my thanks go to John for his support. We will kindly remind you to switch off your microphones, please. Thank you very much. And we apologize for the slight technical issue there has been during the screening of the video. So let's go to today's session. It's dedicated to law and legal issues on trafficking in persons specifically. Although trafficking in persons is defined in international law, many practitioners report challenges in implementing anti-trafficking national legislation. So this session will examine various approaches to what constitutes trafficking and discuss ways in which a common understanding could be built in practice. UNODC has had a long tradition of examining and understanding the implementation of this international definition in member states. For example, what constitutes exploitation, what is consent, or abuse of a position of vulnerability. So for today, let me introduce you to our esteemed panelists. We have Joseph Lelliot. Dr. Joseph Lelliot is a criminal law scholar and academic of the University of Queensland School of Law. He has published numerous articles and chapters on migrant smuggling and trafficking in persons, with a focus on issues concerning the protection of child migrants. We have been working with Joseph at UNODC for many years now, and I've always appreciated his thoroughness, beside the fact that he's also a very pleasant person to work with. He has authored or contributed to a range of reports and other materials for UNODC, including, most recently, the second edition of the Legislative Guides for the Trafficking in Persons Protocol, and a report on the nexus between trafficking, smuggling, and corruption. He is also the author of the issue paper we are launching today on the act of harboring in the international definition of trafficking in persons. Good evening, Brisbane, Australia, as Joseph is joining us very late today. We also have Judge Fiona Mwale. Justice Fiona Atupele Mwale was appointed Judge of the High Court of Malawi in November 2012. She has a strong background in women's rights and children's rights. She also previously headed programs in the Malawi Law Commission that played a key role in initiating changes in these fields, including through the enactment of gender-related laws and a law on childcare, justice and protection. She was awarded the prestigious Humbert H. Humphrey Fellowship at Washington College of Law in the United States, where she also worked with the International Association of Women Judges as a judicial training expert. Her engagement continues to this day, with her recent appointment as a member of the UN Women Regional Reference Group to End Violence Against Women, where she provides strategic direction on programming for the Eastern and Southern African region. So good afternoon, Lilongwe, Malawi. And last but certainly not least, Matthew Taylor. Matthew works at the Department of Justice of Canada, where he is General Counsel and Director of the Criminal Law Policy Section. He oversees the section's cabinet and parliamentary business, including criminal law and regulatory reform. He joined the department in 2003 and has practiced exclusively in criminal law. He and we, at the Human Trafficking and Migrant Smuggling section of UNODC, have had the good fortune of working together while he held various positions with the Government of Canada and UNODC in trafficking in persons, migrant smuggling, and organized crime projects, including in some of the reference tools that we will refer to in our discussion. So good morning, Ottawa, Canada. We have received some questions from registered participants that we have communicated to our panelists during the week so that they can take them into account in their interventions. Would we have time at the end of this event, we will also pick one or two questions from the chat. So let us get started with the first question that will go to Joseph. Joseph, you've been working with UNODC on developing tools that clarify the legal concepts contained in the Trafficking in Persons Protocol. Can you talk about some of the complexities that exist in the international legal definition of trafficking, most notably from the issue paper on the concept of harboring that has been published earlier today and that you can find on our website? Joseph, you have the floor. Thank you.
Okay, thank you very much, Morgan, and good evening, everyone, or good morning, or good afternoon, depending on where you are. It's very late in Brisbane, and it was our hottest day in October as well, so forgive me, I'm not wearing a tie or a jacket right now. So thanks, Morgan, and yes, of course, I'll talk generally for a few minutes just on some of those complexities in the protocol's definition, and then I'll turn more specifically to some sort of issues raised in the Harboring paper. So as Morgan's question alludes to, while the Trafficking in Persons Protocol provides an internationally agreed definition of trafficking, and one, of course, that has been widely accepted, numerous questions do remain over the precise contours of that definition. In particular, parts of it are not defined in the protocol, and they don't elsewhere have established meanings in international law. So we have this sort of lack of certainty over some parts of the definition, and this has led inevitably to differing interpretations of some of trafficking's constituent elements. Just to give one example quickly, the protocol leaves ambiguous, say, the severity of exploitation required for conduct to fall within the scope of trafficking. Indeed, on this point, the recent second edition of the legislative guides for the protocol observe that it can be difficult to discern exploitative conduct that rises properly to the level of trafficking. Aside from this, other persistent issues include the precise meaning of abuse of a position of vulnerability as a means element, as well as the role of consent, and state practice varies with regard to each of these parts of the trafficking definition. So in light of this, as I'm sure many of you are aware, UNODC has produced a range of issue papers exploring these quite often ambiguous and complex issues in the protocol. Before I come to harboring in a second, I'd like to stress that while talking about these issues can seem perhaps somewhat legalistic and abstract, at least to a degree, there are significant practical repercussions to any lack of clarity in the definition, so i.e. what is and what is not trafficking. So for states, first of all, uncertainty over the definition can make it unclear whether their obligations under international law, under the protocol, to criminalize traffickers, protect victims, and cooperate to combat trafficking are activated. For victims, that same uncertainty can impact on whether they are deemed victims of trafficking and thus owed the special assistance and protection measures mandated under the protocol. Clear boundaries around the ambit of trafficking are also needed to facilitate identification of perpetrators and, in turn, to determine whether they are liable to the penalties that attach to the offence of trafficking. It's also worth noting that a clear definition of trafficking in persons is crucial for the purposes of data collection and just understanding the nature and extent of trafficking generally as a phenomenon. So on this background, and as Morgan mentioned just before, the most recent UNODC issue paper on the trafficking protocol concerns the concept of harboring. I believe it became available this morning, so it's hot off the press. One of the act elements, and that's of course one of the act elements of trafficking in the protocol. So while these act elements, including harboring, tend to receive perhaps less attention than the means and purpose elements, they do play an integral role in delineating the scope of trafficking. And harboring, like some of those other issues I've already mentioned, is at one sort of a malleable and to some degree at least an ill-defined concept. But why is harboring in particular important? You might ask, why have an issue paper on it? Well, for one thing, it is arguably the act element that most clearly brings exploitative situations themselves within the scope of the international definition of trafficking. The end or purpose of trafficking, the exploitation itself, thus becomes part of the definition. And the implication here then is that the act element of harboring removes that need for a victim of trafficking to be moved. So just to give an example, for instance, the conditions of a particular place of work may transition from being lawful to exploitative, meaning that workers there have not been brought as such into the exploitative situation, but rather have remained, they have been harbored, in a place that has become exploitative. Notwithstanding the importance of harboring to the scope of trafficking, there is little guidance in the protocol or interpretative materials concerning its meaning and application. So the legislative guide to the protocol notes that harboring may be understood differently in different jurisdictions. So in some languages, it means something more akin to conceal or hide, while in others, it more broadly means to accommodate or shelter. The term appears to be flexible, like other parts of the protocol's definition, and in turn, states parties have a degree of latitude in how the act element of harboring is implemented at the national level. So nonetheless, while this flexibility can be a good thing in some ways, this lack of clarity also has implications for how harboring is understood. So the recently released issue paper identifies some key questions and ambiguities, I should say, around harboring, including whether it requires concealment or simply accommodation of victims, whether a victim must be harbored for a minimum period of time, and whether there is a requirement of sort of so-called substantiveness to a place of harboring. Okay. Indeed, on these points, the issue paper identifies sort of significant variation across different jurisdictions. So a question that flows from this is, well, what do these variations actually mean in practice? Well, I'll just give a few quick examples as I come to the end. So first, in some jurisdictions, to prove the act element of harboring, the prosecution must prove that the victim has actually been held at a place for a substantial period of time. In others, there is no minimum period in which a victim of trafficking can be harbored. It could potentially be mere minutes. Similarly, in some countries, the place of harboring must be a place of accommodation. In others, it simply appears to mean any physical location. So, for instance, the question of whether a person is being harbored while they are at work on a farm could lead to different answers, potentially in different jurisdictions. Okay. So the issue paper explains in detail these and a range of other issues. It includes sort of analysis and conclusions on the concept of harboring at the international level and sort of findings from a range of surveys and interviews of national law and practice. Despite some of the difficulties identified with regard to harboring, some of which I've noted here, one key sort of overarching conclusion is worth stressing, and I'll just sort of point it out in particular. And that is, while the scope of individual act elements of trafficking may vary in different states' parties and may be interpreted in somewhat different ways, taken together, they should always cover the full range of trafficking conduct criminalized by the protocol. And this just leads me to a final and general observation on the international legal definition of trafficking and its inherent complexities. And this is that regardless of these complexities, the definition should be interpreted broadly for the purpose of identifying situations of human trafficking and for the purpose of providing protection and assistance to possible victims. The goal must always be ensuring the widest possible scope of protection for persons who may be victims of trafficking. Okay, thank you. That's kind of my spiel in response to that question. Thanks, Morgan.
Excellent. Thank you, Joseph. And thank you so much for reminding us of the ultimate goal, which is the protection of the victims of this exploitation. So now let me turn to Judge Fiona Mwale. You have been a supporter for strong judicial leadership on implementing and clarifying the legal provisions addressing human trafficking, as we've heard. What is the court's role in clarifying and expanding the notions contained in anti-trafficking legislation, in your view? Can you maybe give us specific examples from your work in Malawi?
Thank you very much. I think Joseph has done a very good job of starting off this, the importance of what I wanted to talk about. Because of the complexity in interpreting legislation, it is not always easy for the judicial officer who sits in a case of human trafficking to be able to expound the notions. And for a very long period of time, we have been plagued by the terms judicial activism, where if a judge seems to be going outside what might be perceived as the norms of what that definition ought to entail, they are branded as activists who have gone beyond their powers. But then that obliterates the most important thing, and that is making sure that there is effective judicial protection to the victims, and those should take center stage. So my starting point would be a quotation from Dr. Gian Marinaro, the Special Rapporteur on Trafficking in Persons, who said that when an emerging crime threatens the whole society, the jurisprudence should avoid a conservative approach. It's time to be innovative in the interpretation of new legal provisions. And I think that's very important, and that's where I start from in advocating judicial leadership. Judicial leadership is about going beyond the realms of what is in front of you to look at the political, social context, because effective adjudication requires you to look at the dynamics involved, to look at the context. And when you look at a crime such as human trafficking, which is very new, it is evolving on a daily basis. The traffickers are getting more and more complex by the, they're using more and more complex techniques. What might be considered as trafficking in one case will not be considered, what might be considered as harboring, for example, in one case may not be considered as harboring in another case because of the circumstances. And so if you impose a straitjacket approach and apply precedent too rigidly, you are not going to do justice for your victims. And so for instance, I say when I bring forward this view that the importance of judicial leadership is one that allows you to look at different dimensions that would ordinarily be ignored if one didn't have a specific lens when looking at trafficking cases. So for instance, you have the gender dimension. And one of the most important things, considering that many victims are victims of sexual exploitation, you have women and children victims. So this brings in the added requirements of you having to protect these women and children who may be too scared to testify by producing a courtroom environment that is sensitive. Now, the legislation, on top of being ambiguous about terms and contexts, will not tell you how to treat victims in these particular cases. It requires the judge to take the lead to go and look at criminal procedure legislation to see what sort of measures he or she can impose to ensure that the victims are accorded extra protective measures. Then there's the whole important issue of balancing the rights of the accused person and the victim, maintaining that balance all the time. And that's a very strong and important component of judicial leadership, because if you are seen to be leaning too heavily on the rights of the victim, you look as though you are trampling on the rights of the accused person. So those are some of the issues that affect case processing. So it's not just about understanding the hard letter law, it's about understanding the context and the dynamics. I will share with you a case, a Malawian case that also brings out the importance of looking at cultural dynamics, which if you ignore based on the setting that you're in, the legislation that is based on international law will not have considered cultural dynamics. So for instance, I'll share with you what in Malawi is called the Kapinga case, which involved the disappearance of a 7-year-old child. Now, this 7-year-old was being cared for by a couple that were not his biological parents. And this couple were approached by a certain gentleman who said, I need you to provide me a child to work in my maize mill. That's a plant that makes flour out of corn. And to anybody else, this would imply that labor was required for this plant. But what he was actually saying, when you hear this in the Malawian context, in that particular setting, is that you need the body parts of that child to use as charms, to use in the maize mill. And so this child disappeared and has since not been found. And this case has been, it has generated a lot of jurisprudence because it brought such public outrage that a small child could be killed and these processes could be he could be exploited for his organs, although there was never any proof of that exploitation. The body hasn't been found yet. So basically, because of that outrage, the judicial officer had to move the case to a very secure place. The trial couldn't be held out of prison, because if they came out of prison, there was so much public outrage, there would have been a lot of violence at the court. So when you now come, he was found guilty, he was sentenced. There were two people, actually, they were found guilty, they were sentenced. And when they were found guilty, they appealed and they said they shouldn't have been tried in a prison that trumped their rights to access justice. But criminal procedure, not trafficking legislation, does provide that where circumstances require, you must take the trial to the safest place. And in this case, it was the accused persons who are being protected. But similarly, if it's a place in which the victim is well known, you don't want them to be coming to a courtroom which is public knowledge and everybody can see them. And again, when you're operating in jurisdictions such as mine, where we're very constrained for and you know, I work a lot with UNODC in the Southern African region, and we share similar resource constraints where we do not have courts that are in secure places. It's a nightmare for these children to come to court and testify because people around the locality may know them and there are no secure rooms to hold them. And in this case, if the judicial officer isn't innovative in holding courts at certain times where people would not accumulate at the courtroom as often, you know, as they would if they were held at normal times, or if they don't impose certain sanctions within the courtroom to say, we'll have the victim testify under a screen that is immediately erected at the time. And these are very simple and practical things that can be done within the context of resources that judicial officers might have. But if you don't operate from that prism, where you're going to start with a victim-centered approach and you're going to use all the resources at your disposal to create a safe environment, you will not be able to think of these things immediately. And you also find that just as traffickers get more and more innovative, as you try to make the trial more victim friendly and to accommodate for these special accommodations, you also find that litigation even becomes more and more complex as the lawyers file one application after another, and which will serve to delay the process. There will be so many applications that by the time you're finished with these applications, you've even forgotten that you were sitting in a trafficking matter. And so judicial leadership, in my opinion, is also about managing the flow of applications that come before the case. And this Kapinga case that I'm talking about is a case in point because there were so many legal arguments that kept coming forward. But luckily, the court was able to identify them and able to say, look, we're going to proceed. These are well grounded in law. And where they're not grounded in law, we have precedent from around the region, we have precedent from the world, that this is a sort of thing that can legitimately be done to protect the rights of victims. I don't know if I have gone over my time, but I think I can stop there.
Thank you so much, Fiona, for highlighting the importance of judicial leadership and also for sharing specifically a very concrete and absolutely horrendous case where you have been able to display the importance of innovation in using the law to protect the rights of the victims, but also of the perpetrators. And this is what we're also acting towards at UNODC. Thank you so much. Now I will turn to Matthew Taylor. Matt, you've been working on national legislative procedures in the field of human trafficking for many years, and you also had the privilege of having a leading voice in the development of the new edition of the UNODC Legislative Guide and the model legislative provisions on trafficking in persons. From your point of view, what are some of the challenges for national authorities in implementing the legal provisions contained in the protocol, and how are the new UNODC tools supporting these efforts? Thanks, Matt.
Thanks, Morgan, and good morning, good afternoon, and good evening to Joseph and others, wherever you may be. I guess I should just start by thanking you, Morgan, and your team for the great work that you've done in putting this event together, and also the whole week itself. It looks like an excellent program, and I think it's really important that your office continue to take leadership on these issues. Given the topic that we're discussing today, we know that there's this constant need for knowledge exchange and knowledge sharing and learning from one another. So congratulations to you and also to the entire HTMSS team for everything you do all year. I know how hard you all work, and it's really appreciated. So I'm gonna go a little bit off my script that I had written out for myself, just to start, given the time that we have, with a plug for the tools that your office has developed, and then move into the specific questions that you've asked. So I think what I would say is, in terms of the legislative guide, the new legislative guide that was launched last year that Joseph's talked about, the model legislative provisions that were also launched last year, the various issue papers that have been recently developed or a few years back in time. I think those are all tools that are extremely important, not only for legislators who are tasked with ensuring that national legislation complies with commitments under the protocol or exceeds those commitments. But I think it's also important for law appliers, those who are responsible for implementing the law, even if they're not the ones responsible for developing or providing guidance on the development of the law. They are responsible for giving it life. And one of the challenges that we see, I think, in all countries is a difference from the law on paper and the law as applied. And in the absence of clarity in national law or in international law, the role of the police officer, the prosecutor, the judge is critically important in giving life, kind of trying to reflect the policy objectives behind the various provisions of the trafficking protocol. So I think for me, that's really important, and the tools that your office have developed, continue to develop, give effect to that in a meaningful way. And I'll try and kind of pick up on some of those themes in the rest of the time that I have. So I've identified 3 issues that I thought would be interesting to talk about in terms of what are the challenges confronting national governments, lawmakers, police officers, prosecutors, judges. And the first one, and none of them are pretty new. They're not new. They're not innovative. They're not. They shouldn't be surprising to anybody. And I think, again, it speaks to the importance of continually sharing information and developing capacity and knowledge. And the first one Joseph's already talked about, and that's the definition itself of trafficking in person and its constituent elements, and how you take that definition in Article 3 and turn it into an offense at a national level and apply it effectively. Joseph's already talked about the differences in state practice, and the model legislative provisions provide detailed information on the variations that exist at the national level on this issue. So, for example, in looking at the 3 elements in the protocol definition, we know that some states have taken all of those elements and essentially crafted it into an offense. Every person who does insert definition is guilty of an offense. Other countries have taken different approaches. They've maybe expanded the act elements that constitute trafficking in persons. They perhaps have expanded the means element. They may have omitted the means element. So there's that variation in the actus reus, or the physical elements of the offense at the national level. And then, of course, the definition of exploitation. What is it? What isn't it? We know that some countries adopt the approach that the protocol takes, which is to provide examples of conduct that are exploitative themselves without necessarily defining those examples. Some of those concepts are defined in international law, so forced labor being a good example. Some countries have expanded upon the list of exploitation to include things like forced marriage being a common example, or forced begging being another common example. So you have that variation in terms of that first approach of defining or explaining what exploitation is, and then you have another approach which tries to define exploitation through some sort of qualitative assessment without reference to specific types of exploitation, but rather the conduct of the accused and its relationship to the victim. So coerced labor without necessarily itemizing the types of labor. So there's a great deal of variation, and I think variation is not necessarily a bad thing. It can pose challenges at an international level for sure, in terms of international cooperation, mutual legal assistance. But I think the protocol provides the foundation or the anchor that allows us some flexibility in how we approach things, to recognize the realities of different national contexts, different legal traditions, common law systems, civil law systems, constitutional differences. I think that's all important. The problem with variation and the problem with the lack of clarity that I see as being particularly concerning is when the people who are tasked with applying the law don't understand what it means. Because if they don't understand what it means, then they can't properly advocate for it in court. They can't properly investigate it, understand what the elements, what the evidence is that they're looking for. So for me, that is where the challenge lies, and why the tools that I've talked about already provide some useful guidance. The second issue, really quickly, that is very topical, is non-punishment. And you, HTMSS, UNODC, have released a paper on this issue last year, and are supporting work on it in other contexts, whether that's through the Working Group on Trafficking in Persons or through the work that you do with ICAT. Really important guidance in this area. Again, a great deal of variation at the national level in terms of its scope, in terms of its application. I think historically that principle has had its roots in a criminal law context, but we have seen it expand into other contexts, immigration proceedings, employment and labor law contexts as well. And so there continues to be, I think, a great deal of interest in implementing the non-punishment principle at the national level. And I think still a great deal of work that needs to be done in understanding its parameters, its the constituent elements. Again, the model legislative provisions and the legislative guide talk about these issues in terms of, who are we talking about, who's entitled to the defense, does the defense or the principle apply to all illegal conduct or a subset of illegal conduct. There is different views on the threshold that should be applied in implementing non-punishment. Is it compulsion? Is it connection, a connection? Was somebody compelled to commit the illegal behavior, or did they commit it in connection with their status as a victim? So these are all questions that need to be understood, considered, and answered when developing and applying non-punishment. And the third issue that I wanted to talk about briefly is just the role of victims and supporting victims in the criminal justice system, allowing them to participate in a effective and meaningful way. Again, how do we do that at all of the different stages, and how do we do it in different legal contexts? Again, common law systems versus civil law systems, within countries where there are technology access challenges, and that can be from urban to rural, or as between countries, more technologically set up court systems versus systems that aren't. And so what are the things that we can do and that countries should do to support victim participation in terms of testimonial aids, video link technology, excluding members of the public from the courtroom, protecting the identity of victims through publication bans or pseudonyms. These are all really important components of effective anti-trafficking responses, and perhaps need to be considered more prominently as we work to support victim-centered responses. And then another issue that the legislative provisions touches upon is rules of evidence around the admissibility of certain information, like prior sexual history of a victim, where that prior sexual history evidence is being tendered simply to discredit the victim and to doesn't otherwise have any linkage to a material issue at trial. And how can governments develop legislation or rules of evidence to support the truth-seeking function of the courts and to have really truly relevant information before the courts. So those are my three issues in 8 minutes, I think, on my count, but I'm probably wrong. Again, I think the legislative guide, the issues papers, the model legislative provisions all provide really important information to guide those responsible in implementing the protocol. Thank you, Morgan.
Thank you so much, Matt, for sharing with us your views on these 3 points you highlighted, but actually there were many more points I think that we can retain, and also for touching upon the principle of non-punishment, which is much talked about at the moment, and there are many advocates for this principle. And indeed, it may have complexities in being implemented depending on the jurisdiction. And the last point you've made about the rules of evidence is also potentially another obstacle that could be found in protecting victims during a trial. Actually, my last question, which I will pose to everyone, is going to give you a chance to elaborate, if you wish, Matt, on some of these points. During today's discussion, we have talked about several tools and strategies to give meaning to the law. Do some uncertainties remain? What legal issues are still unresolved? And of course, we can't list them all, so I will ask you to focus on those that you think are the most important and the most urgent to address, and what obstacles exist that hamper the implementation of the Trafficking in Persons Protocol. These questions are important for the audience to better understand where to act, to also maybe hear reinforcement and echo of their own experience, and also to guide us along with those who are engaged in better acting together against trafficking in persons, to find solutions for everyone, to protect the victims and to get justice. So I will first turn to Joseph, and then I will go to Fiona and then to Matt. You have a little bit less time this time to address this question. So Joseph, please go ahead.
Okay, thanks, Morgan. I'll try to be quick. So I guess the very short answer is yes, there are uncertainties, there are obstacles. Matt and Fiona have both noted some of them already, and there is an ongoing need for the excellent work that UNODC does and continues to do in this space, as Matt emphasized before. I think it is worth emphasizing just quickly, I guess by way of context, that the protocol arose from numerous compromises during its negotiation, and the result of that is that while we have a definition that is carefully crafted and widely accepted, does reflect that need for sort of definitional fluidity and a certain level of ambiguity. And simply put, the protocol leaves room for interpretation by states parties. So, of course, there are sort of positives to this flexibility. It allows states to sort of implement the protocol in ways they think fit, but it also creates uncertainty, and this in turn can complicate efforts to prosecute and combat trafficking in persons. I think one sort of key issue is there is no, I guess, universal and consistent understanding of the exact ambit of trafficking. In other words, what exactly is it and what exactly isn't it? And this means that for some, the crime can perhaps be construed as really quite wide, while for others, it is perhaps simply restricted to especially serious conduct. The line perhaps, say, between more minor, say, workplace violations and situations of trafficking might become blurry in certain instances. I think this is a key issue, and it's one that's likely to persist as well. So not all exploitation is necessarily trafficking, but it is unclear where that line should be drawn. Is it a bright line? Probably not. It's probably somewhat of a blurry line. One downside of this ambiguity is that perhaps it's only the more clear-cut, more extreme cases of trafficking that are the ones that are more likely to be pursued, while the ones that perhaps exist on the borderline are less likely to be prosecuted. Of course, do we want to erase these ambiguities entirely, this one and others? Probably not, given the definition does need to allow for some prosecutorial discretion and that sort of flexibility to respond to evolving means and forms of exploitation. I'll try and be quick. So I was just going to mention that another obstacle is, of course, the fact that it's just difficult to prosecute and investigate trafficking. Many situations of trafficking are simply never discovered. Okay, and in some, significant steps have certainly been taken over the past 20 years or so. And I think we certainly have much more clarity and understanding than we did. And UNODC obviously plays a really integral role in that. But trafficking simply remains a difficult crime to both articulate, to identify, but also to combat and prosecute as well. Thank you.
Excellent. Thank you, Joseph. Thank you for mentioning the hidden figures of trafficking as well. It's an extremely important issue, actually. Now I'll turn to Fiona. Fiona, please, the floor is yours.
Obviously, the barriers that Joseph has mentioned are, they're across the globe. They apply everywhere. It's not an easy offense to articulate. There are so many drafting problems. I have been in fora where prosecutors have had problems just drafting a charge and, being able to fall within the confines of removing ambiguities when the offense itself is drafted in such ambiguous terms. There are other issues such as, exploitation. It's hard enough drawing the line in exploitation, but also in many cases that are discovered, the exploitation hasn't taken place yet, and so it's an attempt. And to get that to come to court and for a judicial officer to decide that trafficking would have occurred at the end of it has been quite challenging. So you're looking at the circumstances that happened along the way. Are they so bad that they would constitute trafficking? But could they be worse circumstances? It's a very difficult thing to grapple in practice. But I'm very grateful for the interventions that UNODC has done, especially in the Southern African region, where a case digest of case law has been put together or is in the process of being put together. Because when you're sitting in your jurisdiction and looking at a case, you think you're alone. And you think, right, these are unsurmountable difficulties. I will never get it. There's no way of getting around them. But I think one of the consistent things the case law is showing is that, by and large, with a lot of training and again with a lot of intervention from UNODC, judicial officers are seeing that what was traditionally in other cases viewed as evidence that would go towards an acquittal is actually in a trafficking case evidence that would lead to a conviction. So where a victim actually tells lies. For a trafficking victim, that's normal. And more judges seeing this across the continent and saying, oh, I won't be faulted for finding that these lies don't acquit, but they actually are in favor of a conviction. So the more we see that sort of thing, the more we're exposed to it, considering that in the region, most of these cases are held at first instance, which are what we call courts that are not courts of record. So their judgments would ordinarily not be shared across. And so we lose a whole lot of learning in that respect. But with this regional case digest, I think judges are being shown a lot more. And finally, I also want to say that, the platform for resource sharing that's being created through these networks is actually quite good because most of our governments don't have the resources to even pay for sometimes an interpreter. And interpreters are being provided for the courts coming from the accused person's pockets because it's the accused who have more funds. And obviously, that interpreter interpreting for the victim will not be giving you an accurate record. And that actually happened in a case in Mozambique where until the transcript was sent to South Africa, they didn't realize that the interpreter wasn't saying what the victim was saying. So by pooling resources, by bringing together countries, UNODC is allowing us to say to each other, do you have this interpreter? And we can do it via Zoom. COVID has taught us that people don't have to move around. We can have one person in one part of the world. And so, just bringing people together, bringing jurisprudence together creates not only a strong resource base, but also strong networks that are going to help us end impunity to trafficking. Thank you.
Fiona, thank you so much for bringing this into the conversation, that indeed there is intervention in the field to support directly practitioners with very, very concrete, in very, very concrete ways, including interpreters. The case digest, I welcome everyone to join the event that will be held on Friday. We will be talking more about the case digest on evidential issues, where you will hear more about the regional versions that have been produced as well and how they help practitioners on the ground. Thank you also for raising the issue of attempts. It's extremely difficult indeed to prove that there was an intent to exploit. And this issue of exploitation in itself also, as mentioned by Joseph beforehand, is also a difficult one. UNODC has actually produced an issue paper a few years ago on the notion of exploitation that I encourage you to have a look at. It's also on our website. Maybe we'll provide the link in the chat. And finally, I'm turning to Matt. Matt, if you would like to elaborate or bring a new point to this last question, the floor is yours.
I'll just be really, really quick so that if there are questions, people can ask them. I guess I'd say two things. One is the importance of understanding the specific context in which the state is responding to trafficking, and appreciating that what we understand to be trafficking can be fluid depending on the context. And the point I'm trying to make, maybe through an example, would be this. In a trafficking investigation and prosecution, the evidence needed, the standard of proof and the burden of proof are significant, as they should be, given we are using a criminal law power to respond to alleged conduct and the consequences for the accused. The standard and the evidence required in other contexts need not be that high. For example, when determining at an early stage whether somebody is a victim of trafficking for the purposes of social benefits or immigration status, if they're a foreign national, the threshold shouldn't be the same as it is in a criminal context, because the consequences are quite different for the victim in that case. So I think we should be comfortable with those differences because the different contexts require different responses. And then just as the last point would be to emphasize again what Joseph touched upon and what others, what we said throughout the presentation, which is the implementation piece around taking the law and applying it properly. I mean, the tools demonstrate that there's a high level of compliance with the obligation to criminalize, but the numbers demonstrate a very low conviction rate, and that is should be concerning to all of us. And notwithstanding the complexities and the challenges of trafficking in persons cases, there is a great deal more that can be done to support proper, effective investigations and prosecutions through training and awareness raising. And a plug to your somewhat dated training tools for criminal justice practitioners as a useful resource there. I'll stop, Morgan. Thank you.
Thank you so much, Matt, as well as for flagging some tools that we continue using, including in technical assistance, and we can also provide you more information about them. Indeed, I think we've heard through this hour, yes, there are obstacles. Yes, there are various ways of... Matt, sorry, you wanted to add something?
Sorry, Morgan, that was an inadvertent button push.
Nice, no problem at all. Yes, so there are various approaches in law, in national law. Something we haven't mentioned at the beginning, but which is important, is that the protocol on trafficking in persons that we refer to is almost universally ratified. So it means that almost all the states have agreed to be bound by it. So that's an extremely important point. But indeed, depending on the jurisdiction, it can be interpreted in various ways and then implemented in various ways. But what we've heard as well, that despite this variety, in most cases there's a complexity, a certain ambiguity in what qualifies trafficking in persons, and it's for the practitioners to overcome. So our tools aim at helping and at bringing the experience of practitioners, including those who have explored innovative ways of overcoming these challenges, including through judicial leadership, as we've heard. These are the type of practices that we aim to capture in our tools, as well as in, for example, our knowledge portal, where we capture case law and legislation and analyze them to put them to the disposal of the public. That's part of Sherlock. We encourage you to check them, as well as our issue papers on various complex issues, where you can learn more about how it's been interpreted and how practitioners have addressed them in order to bring better protection for victims of trafficking and bring perpetrators to justice, as this is our common aim and what the protocol is pushing for. Now, I would like to thank all the panelists and the participants, and as we close, because I believe we did not receive specific questions, I would like to thank the various governments that have supported our work to develop these important tools that were mentioned in the discussions today. We have, for example, the government of the United States of America that funded the development of the issue paper on the concept of harboring in the international definition of trafficking in persons. The government of Switzerland has been funding the new edition of the legislative guide and the model legislative provisions on trafficking in persons, as well as most previous issue papers that clarified various aspects of the international definition, legal definition of trafficking in persons. Sorry. We also have the Organization of American States that translated some of the documents that we mentioned today, and other generous donors that we will be mentioning throughout the week on specific tools. You can find all mentioned tools in the resource section of the website of this event, as well as in the chat, if you have access to the chat. We're very grateful to your consideration of the feedback form that we've added in the chat, or we will add it very soon, and that the registered participants will also receive by email. This will really help us improve the work we bring to you. And now I would like also, as I close, to invite you to join us tomorrow for the next event of the UNODC Knowledge Week. We will discuss why gender and gender equality matter when combating trafficking in persons and the smuggling of migrants. I think that would be an extremely interesting session and one that is very important nowadays. So I thank you all for your attention. Have a wonderful rest of the day or night. Thank you very much, Matt, for getting up so early, Joseph for staying up so late, and Fiona for joining us from Lilongwe. Thank you so much, everyone, and see you tomorrow. Bye-bye.